Hello everyone, Scott Golightly here, estate planning attorney in Richmond's West End. In today's video, I want to share with you the top 4 mistakes I've seen people make in their estate planning. Estate planning mistake number 1 is not having prepared an estate plan at all. Now, whether you believe it or not, you do have an estate plan. Your plan is either by default or by design. That is, if you haven't taken the time to write down your wishes in a legally enforceable way, then the government's going to have a plan for you. The plan the government has in mind for you, however, might not be the plan that you ultimately want. Estate planning mistake number 2 is naming children as beneficiaries on things like retirement accounts and life insurance policies. Many of the folks who have children under the age of 18 have listed those children as beneficiaries on things like life insurance and retirement accounts. Importantly, children under the age of 18 are not legally entitled to receive assets by inheritance, including those assets that come to those children through beneficiary designations. The insurance company or the custodian of that retirement account is simply not going to write a check to somebody under the age of 18. Instead, the person holding those assets is going to require an adult qualified with the court as what we call the guardian of that property to accept those proceeds on the minor's behalf. And that minor child will get the entire amount when he or she turns 18, which in my experience is awfully young to receive assets of any nature, especially large assets like retirement policies and life insurance. Now, estate planning mistake number 3 is leaving all of the assets to one of the parent's children with the expectation that he or she will split those assets among the siblings after the parents both pass away. I've seen parents with multiple children choose to leave one of their children, usually the oldest, as the primary or the sole beneficiary on significant assets. They instruct that oldest child to, quote, do the right thing and share those proceeds among their siblings after both parents are gone. Now, in my experience, this creates at least 2 problems. First, that adult child who received the proceeds is under no legal obligation to share his or her inherited assets with his or her siblings. Second, if that oldest child starts sharing those assets as instructed with the siblings, that oldest child could be making taxable gifts, which could get the attention of the IRS. Finally, estate planning mistake number 4 is failing to update your plan. Now, as we all know, time flies, and I've had countless discussions with clients who last looked at their estate docs 10, 15, or 20 years or more ago. Estate planning is a process, and the plan should be reviewed at a minimum every 3 to 5 years. Things like moving to another state, having children age out of trust that once made sense but no longer do, and ensuring that the people you've chosen to act on your behalf, if you need them, are still the right people, are some of the primary reasons why you should have your estate documents updated on a regular basis. Now, here at our firm, we do pride ourselves on making estate planning approachable and understandable, and we very much appreciate the opportunity to be of service to you and your family and help you avoid these common estate planning mistakes.